thank you so much for joining us today. My name is Adam Hogg. I'm a commercial real estate partner in Mason Hayes and Curran, and I co-lead the dedicated food and beverage sector team in Mason Hayes. Our focus this morning is on the hospitality sector. I'm joined by my restructuring and insolvency partner, Judith Reardon, and employment law and benefits partner, Ronnie Neville. So as we all know, with hotels, pubs and restaurants reopening from this week, we appreciate that business owners are faced with difficult decisions given the new environment and new challenges facing them when seeking to restart trades. I think particularly in the context of the new Fáilte Ireland guidelines, which were introduced just over a week ago, and getting to grips with those and the time and cost challenges involved in complying with those, and the primary focus on social distancing. I think any business that's forced to operate at reduced capacity due to social distancing or limited and no international tourism will have to carefully consider if the business is in fact viable, or at the least how reduced revenues will impact cash flows and the ability to pay creditors. Those decisions are going to be based on certain presumptions and projections that business will return to some level of normality in the near future. So this morning we're going to take a look at some of these issues and hopefully be of some help for you in the next weeks and months ahead. We'll examine how businesses can facilitate a safe return to work for staff, and we'll discuss some of the main issues that our employment law team are facing. We'll also examine obligations of directors and business owners with regards to creditors while maintaining cash flow. Just from a housekeeping point of view, we'd like to make this session as interactive as possible, so we are adopting a Q&A format. You'll see there's a Q&A function on your screen, so please do enter any questions as we go along. We'll try to answer those, as many as possible at the end. So Ronnie, if you don't mind, if we can kick off with you, please. From an employment law perspective, what do you think are the most important issues that directors or business owners should be considering now in their decision to commence operations?
Thanks, Adam, and hello, everyone. I think that the main or predominant focus for business owners who have either opened since Monday or who are looking at opening or ramping up activities over the coming weeks, I think the main issue is health and safety rather than employment. To be honest, I think a lot of clients and business owners have become quasi health and safety experts in the last few months. And at the risk of using one of these kind of US management speak terms, I think this health and safety focus really has to be owned by the directors and managed from the top down. I don't think it's just the employment law focus. I think it needs to be health and safety, looking at you know, the wealth of and volume of information and guidance and help that's available from government or state bodies. I think you've got, I mean, what I'm calling the Bible effectively for clients is the return to work safely protocol. So this protocol document sets out the main thrust of everything that needs to be looked at and attended to in the context of health and safety obligations. And then if you look at all the other sort of information that's available, the NSAI has a great document called the Workplace Protection and Improvement Guide. Also, the HSA has a wealth of templates and documents to be used, and checklists and posters, right? Fáilte Ireland, as you mentioned, Adam, has excellent sector-specific guideline documents. So there's one for pubs, there's one for guest houses and cafes, there's one for guest houses and hotels, there's one for cafes and restaurants. All of this information is there and available. And I just think that the businesses need to look at that health and safety function and engage and read up and study and then put it into practice. First and foremost, it's your risk assessment. You know, whatever risk assessment you had is no longer appropriate. There needs to be a very specific and detailed COVID-aligned risk assessment. You need to look at the training for staff as to how that's going to be put in place. Communicating with staff early doors, not just waiting until they come back into the workplace before they see and they hear all about these new measures. I mean, training in advance and how sort of the processes are being communicated and the basis for these new changes and how it's actually going to work. I think the risk assessment for a big organization is going to look very different to the risk assessment for a small organization as well. A lot of clients are, you know, those who have the resources are investing in a third-party expert, which is absolutely advisable. Some businesses are doing it in-house. If you are doing it in-house, you know, you need to my mind, ensure against delegating that responsibility as a business owner to a mid-manager, because this is just so important. But, you know, that said, obviously needs must in the context of resources. Some people are training up or are using their own internal health and safety delegated person internally. And it's not just sort of the issues around the workspace itself. The risk assessment is going to look at all of these ancillary issues around getting back to work. How are they going to get there? Traveling, looking at issues around the access points and the exit points. Looking around, you know, the what if scenarios. How do you deal with stairs, lifts, toilets? I mean, it's really quite burdensome. There's a huge volume of work that needs to be done. But I think that primarily it's a health and safety focus before you start looking at the sort of the basic employment law issues.
Okay, thanks, Ronnie. And I suppose leaving health and safety aside, then what do you think are the main issues from an employment law perspective, again, in the context of reopening?
I think we've spoken to and advised lots of clients on the practical issues, the issues around managing staff. And it's not to suggest there's not a willingness and an enthusiasm on the part of staff. There's a great sort of an attitude, but that doesn't mean to say that there's going to be, you know, quirky individual, and there have been some, you know, wacky and difficult, trying circumstances which are unique to any particular staff member. And I think that from an employment law perspective, those will include things like, you know, the employer, the business saying, we're going to do a phased return. What does that look like? What's the timeline? How are you going to decide who comes back? And how are you going to select for those who should come back and who shouldn't? Have you been working remotely? If you haven't to date, if the particular business, you know, if that doesn't work, can you look at certain functions working remotely rather than coming back in? Because it's all about risk mitigation. And then how do you deal with these employment law practical issues? Childcare. So obviously childcare has reopened on Monday, but not fully, because there's certain limitations there as well. A lot of these difficulties included staff saying, right, you're inviting me back to work, but I simply can't come back because I've got no one to mind my child. Issues around transport, issues around other personal circumstances. You know, either the staff member has a disability themselves, there could be a carer for someone with a disability, there could be a carer for a vulnerable adult, someone who's cocooning. There could be issues where someone has just been so stressed as a result of the lockdown process that they have got serious anxiety around returning. There could be issues around, you know, how are you going to split the shifts? How are you going to sort of make sure that you haven't got the same volume of staff all sharing the same space at the same time? Can you risk reduce by having split shifts to avoid cross-contamination? Are you going to vary the hours, and what's the reaction by staff in relation to, you know, fundamentally changing their terms? I think the key issue is how are you going to engage with staff in relation to, you know, fundamental employment law considerations. And I think consultation engagement is probably the most important aspect to it. Remember, everyone talks about all these talks we go to and give on attracting and retaining talent, and people say that talent and the people are your best asset. Well, people are going to remember how businesses deal with these issues. And, you know, once this COVID pandemic issue finally resolves or reduces over time, you know, the staff are they're going to remember how well or poorly the business has dealt with them and their issues in the context of the return to work.
Thanks, Ronnie, and that's absolutely understood. I think, Judith, just to loop you into that from your practice area perspective, can you tell us the main issues you think directors should be considering in making the decision to recommence or even ramp up operations?
Yeah, thanks, Adam, and good morning, everyone. I suppose to start with a slightly gloomy piece, trading while insolvent and incurring debts that won't be paid presents high risk for directors. Therefore, from my perspective, I think cash flow management at this stage is absolutely critical. Cash flow is going to look different for a business that's been closed for the last 4 months compared to a business that, you know, maybe have been operating at limited capacity. Equally, some businesses are going to have had financial issues prior to the crisis, and they may have more difficult decisions to make than a business that is only adversely affected by the crisis. But I think regardless of whatever category the business falls into, I think every business needs to have a plan that shows the business is or will become cash flow positive in the short to medium term. So contingencies need to be properly addressed, such as maybe a second lockdown or lower than anticipated customer uptake. The plan obviously needs to be based on reasonable but thorough analysis of the true position that the company finds itself in. And I think it's fair to say that forecasts and projections don't need to be overly conservative, but they do need to be realistic. I think, to take a simple example, a very live example, a restaurant or a hotel perhaps that can only operate at 50% capacity will need to carefully consider its cash flow and how it's going to deal with fixed costs in the short to medium term. So it seems to me that very many businesses will need to look at either perhaps a rent reduction, reduced staff costs, or perhaps renegotiate payment terms with the bank. I suppose, without wanting to labour the point, it's just really important that debts are not incurred if you're not satisfied that they'll be paid. And any problems, be they pre-existing or solely arising as a result of the crisis, they just shouldn't be ignored. They need to be addressed.
Great, thanks, Judith. So what would you say is the key information that business owners and directors should be focusing on in your view?
Yeah, so I guess assuming the plan is to continue trading as normally as possible, I think directors need to pay close attention to up-to-date and accurate financial information, probably on a weekly basis, given the ongoing uncertainty with everything. And it needs to show the cash flow position for probably 6, 10, or perhaps even longer number of weeks, just to make sure that they're satisfied that any liabilities that are being incurred can be met. I think it's also very important to know how much is owed to the business, who owes the cash, and how likely it is that they will be able to pay. What's the value of the stock, and what's the value of or the creditworthiness of customers, and perhaps do you need to give some consideration to being more forceful in terms of collecting amounts due. I think another very important issue is the position with key suppliers. Are they working at reduced capacity? Will they be able to increase capacity if you need them to? Or indeed, are they suffering financial issues such that they may not be available to you, or what the contingency may be around finding alternative suppliers? I think directors also need to be very aware of the liabilities and obligations in loan agreements, contracts with suppliers and customers, perhaps even insurance policies that may have changed somewhat as a result of the last number of months, because it's really important that directors have a clear understanding of what the obligations of the company are in terms of future liabilities, perhaps, and all of those need to be factored into the plan and the cash flow management, because from a director's perspective, if there are obligations that ultimately materialise that they're not aware of, that could also be very problematic for the directors.
Thanks, Judith. Ronnie, Judith touched on the risks of trading while insolvent. From an employment law perspective, where do you see the main areas of exposure, I suppose, for directors and how they conduct themselves when they are reopening?
Yeah, so in terms of main areas of risk, I think it's not just the directors, it's the business owners, it's the managers, and I think that there's duties owed when the business opens the door again to the public. I think you're looking at 3 distinct groups to whom you owe a duty of care, and which gives rise to risk. And actually, curiously, they're the same 3 groups who pose the risk to the business in the context of the spread of COVID. So you owe a duty of care to your employees, you owe a duty of care to your customers, you owe a duty of care to any other third-party supplier or visitor who's coming on site into the cafe, into the pub, into the restaurant. And then when you look at what types of claims are likely to come in the event of COVID being spread in or around or from the business, I think you're looking at personal injury claims. You could possibly be looking at other types of claims, other types of torts. If loss is attributable to a breach of the duty that every business owes. But certainly the most obvious one is your personal injury claim by someone who has suffered injury. I think that this protocol document that I call the Bible, it's a bit unclear as to whether it's unclear to others maybe as to whether it's a guidance or a mandatory. I mean, although it doesn't expressly say it in the document itself, it's clear to me from what government has said that the guidance, that the instructions or directions contained within this protocol are mandatory, and the HSA is going to be carrying out inspections. And in fact, I know of a number of clients who have already had inspections to ensure that HSA guidance and government guidance is being adhered to. That's your second risk, and it's the risk of prosecution by the HSA in the event of breaching health and safety obligations. The third risk is just quite obviously PR. I mean, the last thing that any pub or hotel or any business, hospitality business wants, because they thrive on and they rely on, word of mouth and publicity, is for negative PR to be associated with poor practice or the spread of COVID emanating from that particular business. I think that businesses therefore need to look closely at their insurance. They need to bring in their brokers or involve their brokers, and making sure, to the extent that it's possible, that when you've got insurers who are sitting behind the broker, that the broker advises the business that whatever requirements that the insurers are going to have, which are likely to be more onerous now in light of the greater level of threat, that the business is adhering to whatever requirements that the insurer is going to need. You don't want any risk that the insurance policy can't be called upon in the event that you need to. So you need to involve your broker and make sure your insurance is adequately covered off. And also just, in terms of the prosecutions piece, I mentioned the HSA, and bear in mind that lots of employment legislation and health and safety legislation and other legislation has specific provision around offences. And it's not just the directors or the company itself. There's provisions to the effect that if whatever offence that's been committed is either attributable to or partly due to the neglect or connivance of not just the directors, but also a manager or someone who's acting in that capacity, they also face potential personal liability. So I think there's a sort of a shared investment of interest by not just the directors and owners, but also management in relation to getting the health and safety piece right to avoid those risks of prosecution as well.
Thanks, Ronnie. I think that's a key point from a risk perspective that business owners in the hospitality sector need to be aware of. Judith, just turning back to the then practical issue of reduced cash flow, it may be tempting to pay a useful creditor while not paying one that's no longer useful. How risky would that be from a director's perspective?
Yeah, so this comes up all the time, and of course it is tempting, but I suppose the starting point is that without enough cash, it's always going to be risky to pay one creditor over another. If a company can't meet all of its debts as they fall due, then no creditor should be paid without really careful consideration. That being said, I suppose if it's the case that paying a useful creditor can reasonably be expected to result in a better overall result for the creditors, such as the survival of the company if it is a key supplier, then it may be okay to make the payment. But the most important thing is for the directors or the managers to make that assessment and to document that assessment and the reason for the payment being made. I mean, a simple example that's going to be very current at the moment again is it may be tempting to pay a useful supplier and let a builder who refitted your premises in the last few weeks wait for payment. But as I said, that can be risky and should only really be done within a framework of a plan where the liability of the builder can be paid at a future date. And ideally, of course, by agreement with the builder as to when he will be paid, even if it is a number of weeks or months away, because that effectively removes the threat of litigation or perhaps even a winding up petition, which obviously will distract management from running the business.
Okay, and what about if a creditor is exerting a lot of pressure? Is it okay to sanction payment of that liability ahead of others?
Again, that comes up all the time. And I mean, the courts have made it quite clear that if there is overriding pressure from a creditor, the payment can be made. But again, I would emphasize that this is only okay where the directors believe that the company can survive. If the position is hopeless and a creditor is selected to be paid, then that is, again, is a very risky step for directors to take.
Okay, and then thinking of options around this. So what would your advice be to a business or company seeking additional loan facilities or additional credit terms from suppliers?
Yeah, so I mean, this is effectively the same point, that debts and liabilities should not be incurred where there isn't a reasonable belief that they can be paid. But absolutely, if you can honestly form the view that the company will be able to pay the debts as they fall due, and obviously including any increased loan repayments or longer credit terms with suppliers, for example, then of course it's reasonable to avail of credit or additional loan facilities. And in fact, I'd be surprised if most businesses aren't trying to organise that. Obviously, any decision to take on extra debt needs to be based within the plan in terms of cash flow and the ability to meet those new liabilities. And particularly if a lender is looking for a personal guarantee from the directors, I would suggest that legal advice is taken, because obviously that can be a more complex arrangement and the degree of risk for directors in that instance becomes directly personal if the personal guarantee is called in due course.
Great, thanks. Just to shift to you, Ronnie, and maybe taking some practical questions, I think very important in the context of hotels, pubs and restaurants. What about getting employees back to work? What if an employee just can't or won't come back?
Yeah, I mean, in terms of the practical questions that we're dealing with, we've got 26 lawyers in the employment team. All we do is employment law, and we deal with these kind of practical issues where the client rings and says, I've got this sort of exactly this. I've got someone who's saying they can come back, who's saying they won't come back. And unfortunately, this could be somewhat frustrating, perhaps for some clients, but there isn't any one size fits all. Because, what's good for the smaller employer and business isn't good for the bigger employer and business. There is a question of, everything that you do as an employer is going to be examined by whoever, by whatever third party, in the context of how reasonably you've acted. So, and there's also an issue then in relation to, you know, is it a short-term issue, is it a long-term issue? And exactly when you probe those questions and try to understand the reason for the person objecting and explaining themselves, then there might be some accommodations that can be introduced into the equation. So if you look at like the type of issues that we're facing, people are saying, I can't come back, or I won't come back because I've got childcare issues, or I might have medical issues, which mean that I'm either restricted in my ability to do my normal job, or I can't do it at all, or I'm just not coming back. I think you've got to look at each individual case on its merits. Give you an example. Let's take it to a hotel, and if someone is saying, I'm working at the bar, or I'm working in reception, I'm front client facing, customer facing, and I feel compromised because I've got asthma, or I feel compromised because I've got a child with CF back home, or a vulnerable, I'm a carer for a vulnerable parent or an elderly parent. I mean, all of these types of considerations arise that people know that there's a positive mandatory obligation to provide reasonable accommodation in the context of disability. So you do have to proactively engage with someone if their issue is disability related or associated with someone else's disability, or if it's relating to childcare. Again, there's this discrimination link because it's family status, gender. So, you know, you got to anticipate that there are going to be claims coming down the track. But, you know, depending on the nature of the query or the business, as long as you act reasonably and examine their issue and say, can I accommodate that? Can I move you to a different post, at least in the short term? And if you can, you should do it. And if you can't, then just don't do it. And then if you can't, and then the employee, you know, objects, refuses, you only at that point, once you've sort of, for both employee relations, for industrial relations, for claims, for court of public opinion, at least then you're seen to have acted like the reasonable employer in saying to an employee, I've looked at your issues, I'm unfortunately able to accommodate you to this extent, or not more, or I'm just not able to accommodate you. And unfortunately, then you've got to be looking at either disciplining or potentially terminating employment due to the employee just refusing to perform the employment. But again, I'm loath to give the quick answer that says if someone is refusing or unable, then you can go straight to employment. I just think that there's so many reasons why it's all about the engagement and this fluffy bunny principle of reasonableness. But again, that's the most important issue for the business in terms of sort of future-proofing against the backlash.
Okay, and we've heard a bit in the media about people trying to game the system. What if an employee doesn't want to come back because they want to stay on the PUP payments, or if they just refuse outright?
Yeah, I mean, there's again a bit of media commentary on this recently. I think that most businesses should know at this stage, and a lot of employees should know at this stage, that there's a strict precondition for eligibility for the pandemic unemployment payment, which is that they've lost their job. Now, lost their job doesn't mean termination. Lost their job can mean having been laid off, as a lot of employees in the hospitality sector have been. As soon as the employer says, good news, we're reopening and I'd like you to come back to work, from the moment that they refuse to come back and for the moment that they continue to claim the PUP, that is effectively a fraud on the system, or a fraud on social welfare fraud. And the department and government have made it quite clear that they're going to clamp down. But that's an issue for the state. From an employment perspective, if someone's refusing to come back, then you're back into the disciplinary. But again, I have got some clients who have made it known to the staff that in the event that they refuse to come back and continue to claim that this is a fraud and that, you know, this could be brought to the attention of social welfare, they can't do it.
Okay, and then on the employer side, I mean, obviously the spread of virus at work is a concern for everyone, but can an employer introduce temperature tests now or require staff to wear face masks?
Again, massive focus on both of these over the last number of weeks and months. And I think the answer is yes, you can probably, and I'm not trying to sit in the fence, I'm not going to explain why. I think that practically you can do it, but there's some caveats. I think that, you know, generally speaking, whenever an employer introduces a measure which, you know, constitutes a change to someone's terms and conditions of employment, then Contract 101 and employment law principles require that the employer gets consent. Now, the reality is that we're in a completely unique and unprecedented situation. So if the employer now forces through a change like temperature testing or masks, absent consent, then are we going to be looking at the same reaction by a third party, WRC for instance? as we would have 6 months ago? And I think the answer is undoubtedly no, because it's all got, again, it's back to this concept of reasonableness. So if, in relation to masks, for instance, there's been a roller coaster of mixed messages in terms of their efficacy and, whether they are useful to be used or not. And now government has clarified it. In the last couple of weeks or week or so, they've made it really clear. Every public transport usage requires the use of a mask. Excuse me. Also, if the employer, this is the threshold, if the employer can't safely provide for social distancing, then it's appropriate to use masks. They've given examples in relation to shops or shopping centres and public transport. I see no difference between a direct client example, a factory who says, I can't accommodate the social distancing. And I know that in some of the businesses, it's reduced to 1 metre depending on certain criteria being satisfied. But I think the blanket issue for clients generally is, can you provide for safely accommodating a 2 metre social distancing? And if the answer is no, then masks are appropriate, and it's up to the employer then to decide, I think it's appropriate that I impose upon you a requirement that you wear a mask. Caveat, be reasonable. What's good for now might not be good in 6 months' time or 12 months' time. Also, if someone says, I've got a medical issue, then you can't force it upon them. If someone hasn't got a strict medical disability, but says, I have other reasons, it fogs up my glasses, I hate it, I can't breathe properly, just try to be reasonable. There's visors. I mean, it'll look like they're a welder if they're wearing a face visor, but there are options there, and it's all about the reasonableness of the employer's engagement and reaction to these requests. Similarly with temperature testing, I know some clients have introduced it. I think that Kildare Village has introduced it, not just for customers, but for staff, anyone crossing the threshold. And of course, remember that there's been huge question marks over the efficacy of temperature testing, because if you simply take a Panadol, you're going to reduce your temperature, and then there's a lot of false positives. From an employment law perspective, again, I think that the same issue arises around the masks. If it's reasonable from the employer's perspective to say, I believe that this is a reasonable measure and I'm going to require you to do it, then I think that if someone refuses to do it, then you're into the same issue of possibly disciplining or possible termination. But that's the employment bit. There's a huge data protection consideration around this as well, because medical information, as soon as you take that temperature test, either using the vial or the gun or the passing under the machine, I mean, you absolutely have the processing of sensitive personal data. And then it's a question of, the DPC has said that that this any measure being used, whether it's where you're processing personal data, if it's advised by public health, that's acceptable. Public health hasn't yet said that this is an appropriate measure to be adopted. But equally, the DPC has said that, as long as the measures being taken are necessary and proportionate. So it's up to the employer to decide, how are they going to try to put in place measures to deal with mitigating the risk of spread. If that's temperature testing, you can do it. But you should expect there will be challenges. There will be data protection complaints and or other challenges. So prepare yourself, amend your data privacy notice, minimize the amount of processing, and to the extent that it's possible, don't retain that data. If it's a test, discard it, or I know that certain machines immediately take the test and they immediately delete the information. There's measures that can be done to reduce the exposure.
Thanks, Ronnie. And again, just thinking of other things that employers can do. I mean, can they require that their employees be medically certified as fit to return to work? Or in a related way, can we require employees to complete a health declaration or survey? Or is there any employment law restrictions around that prevents employers doing that?
Yeah, not really employment law. I mean, the protocol document that I've referred to, that expressly has a requirement on employers bringing staff back to ask them 5 core questions that relate to their exposure to or connection to a COVID risk. So that's a prescribed requirement. I've got some clients who are stitching in other questions because they think it's a good idea, and belt and braces, better practice. But of course, you've got this data protection issue as well, which is that the more questions you ask of a personal nature, the more you're treading the fine line over what is the reasonable behavior and action by the employer, and venturing into the more risky territory. But having some form of questionnaire isn't just can you do it, it's you better be doing it. And separately in relation to the back to work certificates, absolutely. If someone has been off with a COVID-related illness, then they're gonna have been certified in any event. So it's not that big a deal to get the doctor to provide a cert. It can be an issue if they haven't been actually unfit, but have been there's some other issue around, maybe they've been confined in isolating with some risk, and then the employer says, I want you to spend the 50 quid on getting a cert. And a lot of employees, who some of whom are lower earners, will balk at that, might refuse to do that. So I just think it's a question of arranging with your OC health specialist. Most businesses should have a strong relationship with their local GP or with an OC health specialist, and just put in place a system whereby if the employer wants employees to get a positive affirmation that they're certified fit, that they could do it through their own employer.
Okay. What about other necessary changes to employment terms and conditions or company policies? How do you go about doing this lawfully?
So all of the things that we're talking about, whether it's masks, temperature testing, go back to earlier considerations where you're saying, look, we're now phased return. We've got flexible hours. Like a lot of the stuff that businesses are introducing constitute terms of employment, which in normal circumstances, you can't just change willy-nilly or unilaterally. You need consent. Now, I've already said that this is a unique situation and there's a huge amount of goodwill, but at the same time, there are certain employees who are struggling to accommodate these new requirements and terms. I mentioned it as well. It's all about consultation, early consultation and communication with the employees. I think is crucial in order to explain why you're doing it and to try to reach agreement in relation to pushback. And even if you don't get consent, if you then fast forward to where is this likely to go, because an employee says, I'm not doing that. I'm just not doing it. I'm not going back for those hours or whatever it is. You're going to find yourself in either the labor court, in a civil court. If you look at the court of public opinion, it's all about the reasonableness. And the employer wants to be able to sort of defend or explain their position by reference to how they conduct themselves, how they try to reach agreement. And if a claim is successful, you'll either defend the claim, first of all, if you explain that you've tried to consult, first of all, and acted reasonably, or even if you're unsuccessful, it's going to reduce the value of that claim significantly if you show how willing you were to try to be reasonable and accommodate. It's all about consultation.
Okay, thanks, Ronnie. That's all very clear. Judith, just to loop you back into this, there's a lot of obviously work and planning invested in preparing for the return to work. But even the most considered plans can fail. What would you say is the key item from what you've already said to mitigate against the risks of personal liability?
Yeah, so I feel like I've been talking about crystal balls a lot over the last number of months, but the reality is that nobody has a crystal ball and none of us know how this is all going to unfold in the coming months. So every plan is going to be based on projections that may or may not prove to be accurate. So I think from a director's perspective, in terms of formulating the plan, relying on projections, it's just really important that they focus on the fact that board meetings need to be held and attended, even if they're on a somewhat informal basis, perhaps in a smaller business. But there does need to be board meetings between the directors with all financial information available to them on an ongoing basis. They need to be careful that it's accurate. So whether it's prepared in-house or by a third party, they need to be comfortable that it's accurate financial information. I've touched on it already, but all decisions that are made need to be documented and the reasons for those decisions. And as I've said earlier as well, all the projections just need to be realistic. So I think it's also important to remember that business decisions are made at a point in time, and courts don't look at decisions that ultimately prove to be wrong through the prism of hindsight, but that's only where those decisions are made in an honest and responsible way. So all of the things that I've outlined are going to be really important and able to demonstrate to a court, if that were ever to materialise, that the directors have acted in an honest and responsible way.
Thanks, Judith. I suppose worst case scenario, if financial difficulties become insurmountable, how quickly should directors take action?
Yeah, so we could talk about this question for a couple of hours, because obviously every case is going to be different. But I think in simple terms, if it's clear that the company is insolvent or on the brink of insolvency, and there's no realistic prospect of being able to trade out of those difficulties, the directors then must act in the interest of the creditors as a whole instead of the shareholders. And they shouldn't delay in taking any proactive steps that need to be taken. Quite often, unfortunately, this may mean ceasing trading and preserving the assets in business and then going into insolvent liquidation, sometimes within a matter of days, if, for example, it's a business that has perishable goods and so on. However, going back to my original point around having a plan and dealing with cash flow management, I would highly recommend that all of the various restructuring options are included in any plan at an early stage, so that if plan A doesn't work out, and it may well not work out, that there is time and cash available to, I suppose, consider further or implement any of the restructuring options that may be available.
Okay, and I suppose when I hear the word insolvency, I immediately think liquidations. You mentioned restructuring there. What other less drastic options are there to avoid liquidation?
Yeah, so look, liquidation is absolutely the worst case scenario, and all other options should be considered where possible. But I think it's also important just to flag that if liquidation is inevitable, it shouldn't be delayed. But looking at the restructuring options is absolutely worthwhile, and restructuring is somewhat of an umbrella term. It captures everything from renegotiating loan terms with your bank to a formal court supervised rescue process, such as examinership, and I suppose everything in between. So it's absolutely worth considering if a business could survive if it renegotiated or avoided the obligation to pay all of its debts in full, if a portion of the business was closed, either temporarily or permanently, if the product line or service offering was reduced. Leases are obviously a very big thing over the last number of years. So if a rent reduction can be agreed, that can often cure a lot of the cash flow issues. Again, bank loans, if repayment terms can be renegotiated with the banks, that will free up cash. And I suppose lastly, and it's more Ronnie's thing, but if you make a number of staff redundant, it may also free up some cash. So in my experience, it's often quite, it's frequently able to agree these with your creditors or with banks or with landlords, or as it may be. But equally, for negotiation purposes, the threat of examinership can also be very useful, because a landlord faced with the threat of examinership may, in fact, be very willing to agree a reduced rent rather than having a court make an order repudiating the lease so that he's left with an empty premises and no rent roll. So I think it's always worthwhile trying to negotiate something consensually, but also consideration should be given to the formal restructuring processes, such as examinership or a scheme of arrangement, which absolutely can deal with legacy debt and onerous contracts. This was just to flag as well that these things usually need to be done quite quickly and before cash runs out. So it's really important that businesses know what liabilities are going to be problematic, what creditors are going to be supportive, what ones are not going to be supportive, and whether only part of the business is viable or whether the whole of the business is viable, and so that any restructuring options can be framed around that.
Thanks. And just as a follow-on, how do you think lenders will respond to requests for further restructuring of loans over the next few weeks and months? And if you don't mind, just link to that. What about, you mentioned leases, what about how will landlords react?
Yeah, so look, I think on balance, banks are going to react quite positively to any borrower that proactively engages and tries to address any cash flow constraints that will impact its repayment ability. But I think it probably depends on the historic relationship between the lender and the customer. I think ongoing and prompt engagement with the lender, I should say, if it's anticipated that the payment terms won't be met, I think it's better that the borrower goes to the bank in the first instance. And equally, if a term extension is being required or a further payment break is required, I think it also needs to be grounded in the plan that I've been talking about. Where is the cash coming from, and when will the bank's liability be repaid? Turning to landlords, I think it's largely the same analysis in terms of the relationship between the landlord and tenant as with the lender and customer. But one thing that I've come across a lot over the years is a landlord may be very willing to agree a rent reduction, but in the background, the landlord in turn has secured debt to a lender, and it's sometimes difficult for the landlord to agree with its own lender to accept a rent reduction, or in fact he or it may not be able to afford the repayments on that basis. So there's another layer involved in the landlord relationship, but I think proactive engagement is always going to be preferable.
Thanks, Judith. Ronnie, just to loop you back into that, what's your key takeaway in the same vein with regards to, considering plans and how they fell from an employment law perspective? What's your kind of key takeaway on that front?
I've said it. It's woolly in relation to reasonableness, but I think it all falls back to communication and engagement with the staff. And I said to a client last week, and I said, fail to prepare. Like Roy Keane said, fail to prepare, prepare to fail. And the client said, well, that's actually Benjamin Franklin. But anyway, the point is well made. It's all about the preparation. And I know most clients and businesses have put in huge investment, but I just think that there's a lot of learnings to be done around the health and safety piece. And then it's just about embracing the consultation with staff. I think that'll reap the reward in the context of risk mitigation.
Thanks. Okay, thanks both. I think there's clearly a number of legal considerations to be taken into account when reopening, both from an employment law perspective and managing cash flows and creditors, as we discussed throughout that. I think we're at 11:40 now, so we'd like to open the floor up to a number of questions, which I can see have been posted over the course of our talk.
Yeah.
One for you, Judith, if you don't mind. I've heard that examinership can be very expensive. Is it worth it?
Yeah, okay, so it absolutely can be an expensive process, but I suppose the starting point is that Aircom obviously was a huge examinership, but examinership has also been used by smaller companies. I was involved in an examinership a number of years ago where there was just 2 pubs involved. So it's not necessarily only for your large and well-known companies that have loads and loads of cash available to them to deal with legacy debt. It can be very effectively used for smaller businesses. I think the huge advantage over any of the other processes that we have in Ireland is that it gives you the immediate protection from creditor action. So again, going back to the point I made about knowing where your problems will lie and how supportive or otherwise creditors might be, if you know you have a creditor that's going to be particularly difficult, examinership may be something that is worth considering, because as soon as the papers are filed in court, that creditor can't take any further action. Some people might remember the Ocean Bar examinership a number of years ago, where ACC was particularly vigorously opposing the examinership. And, you know, it's just a good illustration of the fact that it's the court supervised process that examinership is, and the insulation from creditor action is probably one of the best benefits of the process overall.
Perfect, thank you. Ronnie, one question for you. What happens if a staff member says they're not comfortable performing role, even if safety measures have been put in place?
Yeah, so one line answer is, as I said before, if you've done all that you can, and the employee is either refusing or unable to perform the role, you're going down the disciplinary or termination line. So I suspect that answer came in before I touched on that issue, but ultimately you are looking at dismissal or termination. There's a few questions. I can answer a few of these questions that I see for me in one-line answers.
Yep.
As someone has said, have you seen any COVID-related employment claims coming in through? And if so, what do they focus on? I've seen a number of threats of claim, and a number of my colleagues inside the employment team have seen threats of claims, because obviously when people are their back against the wall and they're being put under pressure by a business, sometimes not unreasonably, right, to come back to work because the business is trying to survive, the employee is trying to survive and look after their requirements. But ultimately there's the threat of, you know, I'm going to take legal action up to and including discrimination claim or constructive dismissal. Ultimately, go back to the first answer I gave a moment ago. If someone is invited to come back, requested to come back, directed, instructed to come back, and they're refusing to do so, provided you do that consultation piece, which I think is crucial for so many reasons, then I think, you know, you're actually acting fairly in the context of potentially dismissing or first disciplining and then dismissing. Someone asked about the insurance position, and they said, what's the point in consulting with your insurance broker about the liability and risk if the insurance companies are blanketly refusing to pay the claims? I'm not talking about business interruption or those policies that relate to loss from business interruption or those policies. I'm talking about your public liability and your employer liability policies, where you just want to make sure that your measures get the broker involved to make sure your insurance is up to date, most fundamentally, so that if a personal injury claim comes through, you're not going to be found wanting. That's it from the...
Great. Thanks, Ronnie. I'm just conscious we're right at the very end. So I think just to conclude matters, again, just to say the purpose of our webinar today was just to highlight some legal considerations business owners in the hospitality sector should take into account. The new environment means businesses need to be able to adapt quickly, both in terms of their premises and how they train and manage staff, as Ronnie went through in detail. It'll be a challenge, but I think those who do it now will develop an advantage over their competitors. Positive news is I think hotels, restaurants and pubs are going to be very busy from this month onwards. So hopefully this session was useful. And as ever, if you have any questions or legal queries over the next while, please do contact us. I'd just like to thank our speakers today and thank you all for your time, and just to enjoy the rest of your day.